A good afternoon. Wednesday, June the 11th. The workshop lecture of the themes of week 6. And that is, ladies, fix the hair silently. So it's about the Rome regulation. And on the slides you see the workshop lecture questions. And those questions could appear in the exam. Ladies, silently. And so continue to fix the hair, but silently. And the first question is, what is the difference between the convention and the regulation? So that starts with the question, what is the Rome Convention of 1980? So this is a small essay. So tell me, what is the difference between the two? Convention is a treaty.
The regulation is not.
And the regulation is not a treaty. Very good. And the regulation is what?
It's directly applicable. You cannot make a reservation. It's a uniform law, strong law. It's a different type of law.
Exactly.
You can ask for interpretations as regards to this.
Exactly. So when you talk about sources of EU law, how would you label a regulation? Say it again. Secondary law. So primary EU law is what, neighbor? Primary EU law is what? So the treaties. And secondary EU law is regulations. And the other animal? Directives. Okay. And the difference between a directive and a regulation, neighbor? Just to warm up. Oh yes, at the end of year 1. But it's early morning. Directive, regulation. The difference? Yeah.
Member states shall adopt it in national legislation.
Yeah, implement it. And regulation is directly applicable. So, we talk about it, regulation. So that's directly applicable. Does that mean that the national legislators are not allowed to translate it in their own language, in their own codes? No. So they may copy-paste, as long as it is exactly the same. And so you can find the content of the regulation in the member state's local legislation. But that is just sort of convenience, that the practitioners, the legal practitioners, can find all the rules in their codes they are used to. Civil Code, or the Act on Contracts in the UK, or when we talk about the Brussels regulations, about the jurisdictions of courts, that is then in the legislative dealing with the jurisdiction of courts. But on a copy-paste basis, and the text of the regulation is binding and guiding the interpretation. And the highest interpreter is then the Luxembourg-based European Court of Justice. That's one aspect. What is the other aspect of the difference between the convention and the regulation? So we move on the first row to the next neighbor. So apart from the sort of sources of law story, what is content-wise the difference between convention and regulation? Yeah. So is the regulation a exact copy-paste of the convention?
No.
No. So it's not completely copy-paste. Why? Because there are 28 years in between. And the development of private international law in the European Union did not had a standstill in those 28 years. So there were sort of progressive developments. And what is the sort of neighbor example we use in that respect? So which article is sort of dramatically or slightly dramatically changed? Come to you, neighbor. We move to the next row. Sir? Who? Yes?
It's about Article 81, and they changed the wording from promote to ensure that...
Okay, but that is the legal basis. So another story is that nowadays the EU can act in these matters in a different way. So that's right. But when you look at the instrument itself, so with instrument we mean the text, you know, the Rome Convention 1980, text, Article 1, 2, 3, 4, and the regulation. Yes, sir.
Article 4.
Yes. And what sort of the progress?
They made the and rules to make it easier to apply
Exactly.
the law.
So the article that deals with the applicable law in the absence of a choice by the parties is more straightforward. And how? So Article 4, Paragraph 1. Sir, with your black t-shirt, yes? So the first quick and dirty rule.
Article going back.
Yes?
To the extent that the law applicable to the contract has not been chosen in accordance with Article 3, and without prejudice to Articles 5 to 8, the law governing the contract shall be determined as follows. A contract for the sale of goods shall be governed by law of the country where the seller has his habitual residence.
Stop. So that sentence once more. Over here. So the sub A that is? So the seller story? Is it sub A or sub 1? A. Okay. Once more. Sub A. Loud and clear. You. 4, but on just the sub A.
Okay. A contract for the sale of goods shall be governed by the law of the country where the seller has his habitual residence.
That is the quick and dirty rule. Where in the convention, it was about the sort of the party that performed the characteristic performance, and then the country in which that performer was located that was providing the applicable law. That is simplified. So the regulation is a simplified version of the convention, as in sale of goods. You have a seller and a buyer. And then when it comes to the applicable law, it's the law of the state in which the seller has its habitual residence. That's what I call a quick and dirty rule. Why, neighbor? Do you know, is it always clear with the sale of goods, who is the seller and who is the buyer? And if so, how do you know?
Well, the one who performs is the seller, and the one who buys is the one.
Okay. And in a transaction that is under the label sale of goods, how do you know who is the seller and who is the buyer? So, how do you know which of the two parties is the seller and the buyer?
Where is stuff is delivered?
Who pays the money, who is the invoice.
So, in a transaction of sales of goods, you claim that one party is paying money. Is that what you claim?
Yes.
And by definition, what is the other party doing?
Providing service or a good. Or selling a good.
And so, why do we call it a quick and dirty rule? Because in a contract for the sale of goods, there's always a fixed role division. There's always a role division. One party is owning the good and transferring ownership of the good to the other party. So when you take a photo finish of the contract, then always on the one side of the finish, you know, in athletics, you know, you have the photo finish, you know what I mean? And you can make click, 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 all kinds of pictures. So in a sale of good contract, on the one side of the finish, one party is the proud owner of the good. That is the seller. And then on the other side of the finish, the other party is the proud owner of the good. That's then the buyer. And then on the same picture, you see the money going the other way around. So that is why you always know who is the buyer, who is the seller. And the quick and dirty aspect is also that we point at one party that provides, or his country, or its country, provides the applicable law. So no further deliberations on how do they feel and were they in space when they contracted or in which language. No. So that is the progress. Why? Because in the internal market you know what your rights are. You want to have legal predictability. You want to know in advance what your situation will be. So it's helpful for the economy that there's no question mark on which law applies. There are 500 million citizens in the EU who conclude trillions of transactions every day. And for all those transactions for goods, you know, supermarkets, you know what the applicable law is. So 99% of all the transactions in the EU are settled with this one sentence. Alright? That gives stability. Because you check who's the buyer, where is its habitual residence. Hey, that's another question. What does the concept of habitual residence refer to? Over there. Your neighbor. Can you do this? Yes. Habitual residence.
Habitual residence is where the transaction is actually made.
Where the transaction is made. No. Neighbor. Well, pay attention.
The place of performance, the place of residence of the party.
Yes. And on what authority do you base that correct statement? So, as I always say in the art of lawyering, I need an R for any statement. So which address has this statement? And you open the law collection and you pick the color marker so that in the moment of panics during the exam you remember this coloring.
Article 19.
Wonderful. So your neighbor will tell us what is in Article 19. Loud and clear. Yes.
The purpose of the stipulation we have no residence.
Okay. This is an exercise of speaking in public, loud and clear, and we help her by being.
The habitual residence of companies and other bodies, corporate or incorporated, shall be place of central administration. The habitual residence of a natural person acting in the course of his business activity shall be his principal place of business.
So here we have 3 types of animals appearing. Which 3, neighbor?
Companies,
That are, and we did corporate law, so
incorporated and incorporated.
we have incorporated entities, so legal persons, non-incorporated entities, and natural persons, but then not as consumers, but as
Acting in the course of business.
acting in the course of business. And then it's either the central administration, or when it comes to this natural person, say it again.
Principal
principal place of business. Okay. So the natural person, based on corporate law, we call sole proprietorship. And then the non-corporated are sort of partnerships and all kinds of other forms, legal forms of enterprises or undertakings. And then the corporations are the public or private limited liability incorporated companies and so forth. Question 2. The classic lawyering theme of the scope of the legal rule. And that is something your brain is doing each time you apply IREC. You do the scope test. Is the R I choose applicable in the situation I want to apply it on? And that depends on, among others, the scope. So which two, neighbor? Over there. Which two main aspects of this scope did we identify in the lecture? Yes, you. Check your notes. Neighbor? Territorial. And time. Time aspect, temporal. So there's a time aspect and a territorial aspect. Well, neighbor, what is the territorial aspect?
Territorial aspect. Well, it has the European Union, with exceptions of Denmark, and UK being a part of it. But it has to do that the applicability is of the conduct where it is applicable.
Yeah. And so, in this stage, year 1, you should at least know it's the European Union minus Denmark, because that has to do with the sort of EU arrangement that where it comes to secondary law, Denmark reserves a sort of special position. Also the UK reserved a special position, and each time the UK indicates whether they join the secondary instrument. And this is an example in which the UK indeed joined this regime. So that also the, what is it, 68 million UK citizens are bound by the quick and dirty rule that the seller determines the applicable when it comes to goods. Then the temporal aspect. Let's move to the next neighbor over there in the grey t-shirt. What is that about? Then based on your logic that is triggered by skills 4. It is. You're not aware of it, but believe me. Exactly. And your authority for that statement is? Article 28. It applies to contracts after 17th of December 2009. When did the instrument entered into force? Neighbor. One second. And what is your authority on that?
The name of the document, regulation number of the European Parliament and Council law 17 June
Okay. And if you check the last article,
Article 26.
say it again.
Article 26.
And Article 26 says what?
No, wait. No, 29.
29.
This regulation shall enter into force on the 20th day following the publication in the official journal of the European Union. It shall apply from 17th December 2009.
Okay. So, each legal instrument on the globe has a clause, hopefully, on when it enters into force. And you know the decision-making process, quarter 2. So you know that there are all these stages, and it is signed on the June, and but no one knows that it will be the June. So they build in a sort of mechanism that this constitutional law, quarter 2, Mr. Spakel, that it is announced to the public through the official publication. And that is a sort of sure moment. And then you give the affected actors, citizens, member states, 20 days or 1 day or 1 year, the time to get used to it. When it comes to entering into force. And in parallel to that, they already set a date for the contract. So they hoped that by the time it was 2009, December, someone put it in the official journal. Otherwise, those two clauses conflict with each other. So this is where bachelor jurists come in. They tell their boss, we should publish, otherwise we run into problems with the 17th of December. Because if it is not entered into force, then the 17th of December 2009 is not in force. So you sign it, you publish it, and then somewhere it says how much later it enters into. Okay, that's important. It's not important, but that is just to use this example on the technique of creating legal binding instruments. Yes?
What's the difference between entering into force and applying?
Well, that depends on the instrument, but one of the statements we said on regulations is that they are directly applicable. And then you need to know, as a member state, and as a citizen, EU citizen, or someone who's active in this economy, is this regulation a real one or not a real one? Is it a draft or is it a real one? And then the difference is that it entered into force. So entering into force means that it is serious business and that the legal consequences are there. Before entering into force of any legal instruments, including contracts, there are no legal consequences. So that is the swap moment. And then, if the legal instrument is about certain activities, for instance, entering into contract, then you can add a sort of additional date, in this case half a year later, in which sort of contracts are affected. And you see that more often, most popular in directives, that you say, dear member state, you have 2 years time to implement, because you have to go through all those steps. So the directive enters into force, and then the additional clause says, okay, take the next 2 years to implement it, and that's relevant, because if a member state does not implement it, then you have the state responsibility and other topics of quarter 2 and quarter 3. Remember? Does that answer to your question? Cool. And knowledge in law school builds up. So in quarter 4, even if it's about applicable law, we are able to ask these types of questions. So that you increasingly add up to the final assessment in year 4, where you have this sort of conversation, an intelligent conversation, where you sort of tell like law and cases and, you know, wonderful. You will be fine. Well, question number 3. How do you determine the applicable law? Because that was the whole issue. Question 3. And we are on the 3rd row, and we are moving to the neighbor. So, it's a little bit of a trick question.